The Public Protector State Capture Report, The Nation in Labor Pains. South Africa's constitutional democracy was born amid hope, pain, and high expectation. Like any new nation, it would be tested not only by its ideals, but by the conduct of those entrusted with power. Few moments expose these tensions as sharply as the release of the Public Protector's State of Capture report. The report did not emerge in a vacuum. It was the culmination of years of institutional strain, political resistance, and constitutional contestation. In many ways, it represented a nation in labor pains struggling to give birth to accountability in the face of entrenched power. The origin and definition of the Office of the Public Protector. The Office of the Public Protector is a constitutional institution established under Chapter 9 of the Constitution of the Republic of South Africa, 1996. Its origins lie in the global tradition of the Ombudsman, first developed in Sweden in the early 19th century as an independent official tasked with investigating maladministration and abuse of power in government. In South Africa, the office was designed as a safeguard against the excesses of state power, particularly in light of the abuses of the apartheid era. Section 182 of the Constitution mandates the Public Protector to investigate improper conduct in state affairs, report on such conduct, and take appropriate remedial action. The office is independent, subject only to the Constitution and the law, and must act without fear, favor, or prejudice. This independence would soon be tested in profound ways.
Like other Chapter 9 institutions, the Office of the Public Protector was created to strengthen constitutional democracy in the Republic. To achieve this crucial objective, it is required to be independent and subject only to the Constitution and the law. The Constitution demands of it, as with other sister institutions, to be impartial and to exercise the powers and functions vested in it without fear, favor, or prejudice.
The Nkandla saga and the Constitutional Court challenge. The first major fault line emerged with the Nkandla scandal. President Jacob Zuma had used public funds to finance extensive upgrades to his private residence, including non-security features such as a swimming pool, amphitheater, and cattle kraal. The Public Protector, Advocate Thuli Madonsela, found that the president had unduly benefited and directed him to repay a reasonable portion of the costs. Zuma and his allies challenged the binding nature of the Public Protector's remedial action, arguing that her findings were merely advisory. This dispute culminated in the landmark Economic Freedom Fighters v. Speaker of the National Assembly judgment in 2016. Constitutional Court decisively affirmed that the Public Protector's remedial actions are binding unless reviewed and set aside by a court of law. This judgment elevated the office from a perceived moral watchdog to a constitutionally empowered enforcer of accountability.
In the result, we make the following order. 1. This court has exclusive jurisdiction to hear the application by the Economic Freedom Fighters. 2. The Democratic Alliance application for direct access is granted. 3. The remedial action taken by the Public Protector against President Jacob Zuma in terms of Section 182(1)(c) of the Constitution is binding.
Zuma, the Guptas, and the capture of the state. As the Nkandla dust settled, a more insidious narrative began to take shape, one not merely of corruption, but of state capture. The Gupta family, business associates of President Zuma, were alleged to have exerted undue influence over executive appointments, procurement decisions, and the functioning of key state-owned enterprises such as Eskom, Transnet, and Denal. Whistleblowers, leaked emails, and public testimonies painted a disturbing picture. Ministers allegedly offered positions in exchange for compliance, institutions hollowed out from within, and governance subordinated to private interests. The state, it appeared, was no longer merely failing, it was being repurposed. The Public Protector's State Capture Report. Against this backdrop, the Public Protector initiated an investigation into allegations of state capture. The resulting report, State of Capture, documented prima facie evidence of improper relationships between the Gupta family and senior government officials, including the president. It highlighted how constitutional and statutory bodies had been manipulated or bypassed to serve private ends. Significantly, the report did not make final findings of guilt. Instead, it recommended the establishment of a judicial commission of inquiry, appointed by the Chief Justice, to investigate the allegations fully. This recommendation reflected both the gravity of the allegations and the limits of the Public Protector's investigative powers. Zuma's court challenges and attempts to interdict the report. As the report neared completion, President Zuma launched a series of legal maneuvers to delay and ultimately prevent its release. He sought to interdict the report, arguing that he had not been afforded sufficient opportunity to respond and that the Public Protector had exceeded her powers. These last-minute court applications were widely criticized as attempts to frustrate accountability. While some procedural concessions were made allowing Zuma additional time to submit representations, the courts ultimately refused to block the report's release. The report was published in November 2016, in the final days of Madonsela's term.
It is ordered to publish the report forthwith and by no later than 1700 hours on 2 November 2016.
A victory for the opposition parties. President Jacob Zuma, who contended his rights to question witnesses were infringed, made an about turn. In a statement, he says it is in the interest of justice and a speedy resolution that he withdraw the application. However, he will study the report to decide if it should be taken under review. This has been the contention of intervening parties since the application was launched.
Attempts to review and set aside the report. Following its release, Zuma moved to review and set aside the State of Capture report, particularly challenging the remedial action directing the Chief Justice to appoint the Commission of Inquiry. However, consistent with the Nkandla precedent, the courts reaffirmed that remedial action stands unless successfully reviewed. The judiciary's firm stance ensured that constitutional accountability mechanisms could not be neutralized by political power. Eventually, the Zondo Commission of Inquiry was established, giving institutional form to the labor pains first articulated in the Public Protector's report. Conclusion: the State of Capture report marked a defining moment in South Africa's constitutional journey. It exposed the fragility of democratic institutions, but also their resilience. The office of the Public Protector emerged as a midwife of constitutional accountability, strained, attacked, yet unwavering in its mandate. Like labor pains, the process was painful, uncertain, and divisive, but it signaled the possibility of renewal. The report did not end corruption, nor did it instantly restore public trust. What it did was reaffirm a fundamental truth, that no one, not even a president, is above the Constitution. In that affirmation lay the promise of a democracy still struggling, but not yet broken.